Good afternoon, everyone, and happy Thanksgiving. Next week is Thanksgiving. We're almost at the end of 2020. Today, we're going to do the broad overview of workers' compensation that we call Workers' Comp 101, and we'll have some special information about COVID. But before we get into the entire system of workers' comp, which kicks in when there's an accident, let's talk about what we can do to avoid an accident or illness in the first instance. How do we create safer workplaces? Well, we have a suggestion that is widely used in industry. Form a labor management safety committee. This is appropriate for anyone who's on this call because everyone has a workplace. Every workplace could have this. The goal is to eliminate accidents and illnesses before they even happen. So how do you do it? Well, why don't you make a committee that has an equal number of workers and managers on it? And then pick a chair and rotate it regularly, whatever schedule works for you. Meet regularly on whatever schedule works for you. Have an agenda. And then discuss the places in the workplace where incidents could happen or maybe have been happening with some regularity. The idea is to mitigate, eliminate future incidents, whether they be injuries or illnesses. This is not a workers' comp claim review. I know a lot of organizations do that, and that's fine. But this is strictly safety. And the goal here is to make sure that the workplace itself is safe, but also review the equipment that you use. Are you using the equipment safely? Are you conforming to the manufacturer's specs on the equipment use? Do you even have those specs? Do you have safe procedures established for doing the common tasks? Who's training the workers on the safest way to do procedures? So this is an overarching review of what do you do and how do you do it in the safest manner. This works, it's simple, and it's free. And you could save an injury, an illness, or a life. Okay, so now moving into the workers' compensation system. It's a no-fault insurance system. That means that employers must carry insurance for their workers in the event that there's an injury or an illness that happens on the job. That insurance is going to pay the benefits. The Workers' Comp Board, my employer, we do not pay the benefits, except in one instance when the employer doesn't carry insurance. But we will discuss that when we get up to that. So the overwhelming 99.9% of claims, there's an insurance company in place to provide the benefits. And of course, the workers do not contribute to the cost of this insurance. You will not see a deduction on your paycheck for this insurance. Workers are entitled to these benefits no matter how the injury or illness occurs. That means no fault. Whose fault the incident is, not a factor. Also, it is a worker's legal right, so it cannot be negotiated away. It cannot be signed away. Actually, the workers' comp law provides for certain benefits. It's possible for workers to negotiate even richer benefits. It's within the realm of possibility. But the point I'm making here is this is a worker's legal right. On the same topic, immigration status is not a factor. That bears repeating. The immigration status of a worker is not a factor at all in the workers' comp system. I was going to say that one does not need to be a citizen to be eligible for workers' comp. Working on a visa, HB1 or some other visa, not relevant. The only thing that's relevant is, were you a worker? Was there an employer? Okay, now we're in the workers' comp system. And also, I'd like to point out that Governor Cuomo signed an executive order several years ago, number 170, you can see on your screen, that prohibits the presence of federal immigration officers on state property or in New York State government offices. And I can tell you from personal experience, that is enforced. Finally, if a worker does not speak English as a primary language or is not comfortable speaking in English, well, we have free language assistance services available. We will interpret, we will translate, we will put people on the phone to help with a hearing, or if the worker calls in for customer service and doesn't speak English, well, we get the indication, we bring a translator or an interpreter, I should say, on the line, and then the three of us, the board employee, the worker, and the interpreter, will have a conversation just to make sure that the person can understand what's happening. My agency is the Workers' Comp Board. We are the administrator of the workers' comp system. We have about 1,100 employees statewide and about 26 offices and hearing points all across New York. We receive the reports of injuries. We receive the reports of payments. We receive copies of all the documentation in a workers' comp claim. We're available for assistance, customer service-wise, my office. We also hold hearings when they're appropriate to adjudicate a claim. So sometimes a claim comes to the point where a hearing is required in front of one of our law judges to move it forward or to get a decision on one topic or another. We hold those. This is my office, the Advocate for Injured Workers. Technically, my title is Ombudsman. So an ombudsman helps well, in my case, the injured workers. You could have an ombudsman in other types of organizations too who help the clients or the customers. I help, and the people in my office, we all help injured workers when they have some difficulty accessing their benefits, or if the claim is very complex, which certainly can happen. We can explain things, we can help move a claim forward, we can contact various parties to a claim to see about moving the claim forward. We're also involved in fatality claims. We had a question before we began where someone was asking if we were going to review death benefits, and the answer is yes. We will get to that in about 20 minutes. But my office makes the initial contact to surviving families to let them know that a benefit exists and here's how you claim it. We also work closely with the 9/11 community because it's been 19 years, but that situation is ongoing. Let's turn now to the claim. Here's a very good introduction to a workers' comp claim. Who pays the benefits in a workers' compensation claim? Well, if the employer has an insurance policy, the insurance company, known as the carrier in our vernacular, the carrier who wrote the policy is going to pay the benefits. New York State Insurance Fund, Travelers, Liberty Mutual, Fire Districts Mutual, and so forth. Those are all examples of insurance carriers. And by the way, there are roughly 260 different insurance companies in the state of New York who are licensed to write workers' comp insurance. It is also possible for an employer to self-insure. That means the employer has set aside funds to pay the claim benefits from its own revenue. most municipalities in the state of New York are self-insured. There are also roughly 125 very, very large corporations who are self-insured, and they are regulated by the Workers' Comp Board. They've posted security deposits. So the benefits are going to be paid either by the carrier or technically by the employer itself if it's self-insured, but this is what you need to know. The self-insured employers tend to hire a claim administrator to handle the claim itself and the payment of the benefits. So if you're a worker and you have a workers' comp claim, you will almost assuredly be dealing with either the insurance company, if the employer bought a policy, or you're going to be dealing with the claim administrator if your employer was self-insured and they hired a claim administrator. So that's a long way of saying we get these questions from workers in my office about my employer and my claim, and it's the insurance company or the claim administrator who the worker is really dealing with in a workers' comp claim. Businesses with employees need to carry insurance. Most nonprofits with employees are also required to have insurance coverage. The exceptions for a not-for-profit to have, well, to be exempt from insurance regulations are very limited. We'll talk about that. Well, why don't we talk about that now? If we're in a not-for-profit, anyone who's compensated and provides services to a not-for-profit who's not clergy, who's not a teacher, or who doesn't do manual labor, well, they might be exempted. But other than that, a not-for-profit, they should be carrying insurance. Anyone providing services to a for-profit business, well, might be considered an employee of that business and therefore needs to have insurance coverage. The business needs to have insurance coverage. Now, let's talk for a moment about who's an employee and who's not. There's a lot of talk in the public about independent contractors. Let me address that right now. Please be aware that when it comes to independent contractors, an organization, I won't call them an employer because they're not an employer if they have independent contractors. An organization might not need workers' comp if it has only independent contractors. But now the question is, who's an independent contractor? Okay, here's how that goes. Number one, please be advised, please remember, independent contractor is a term that is used generally and broadly in all sorts of ways by all sorts of people, but it's also used by government agencies and entities, and each one has its own definition because each is probably operating under its own set of laws. We're operating under the workers' compensation law in the state of New York. That's my agency. Well, the New York State Department of Labor also uses the term independent contractor, and they're operating under labor laws. The Federal Department of Labor might conceivably talk about independent contractors. They have federal laws. The New York State Tax and Finance Department is also interested in independent contractors. They're operating under the tax law. And then the federal IRS, they might have something to say about independent contractors too. So the point here is this. It's possible to be an independent contractor in one context, such as for tax purposes, and not an independent contractor in the workers' comp system. because we all operate under our own laws and we all have our own tests. And in New York, it tends to come down to direction and control. Does the prospective employer exercise direction and control over the activities of the worker? So at a restaurant, for example, the person who comes in to fix the air conditioning in July and then leaves, not an employee, almost assuredly not an employee of the restaurant, probably somebody else's employee. But the people who are working in the restaurant, the waitresses and the waiters and the chefs and the hosts and hostesses, the busing staff, they're probably employees of that restaurant, even if they're getting paid on a 1099, which might make them an independent contractor for tax purposes. But if the restaurant is exercising direction and control, well, it's very possible that if there's a claim, they're going to be found to be employees. And that also sweeps in some internet businesses, by the way, or such as ride for hire, Lyft, Uber, that sort of thing. Those rideshare businesses, by the way, they do carry workers' compensation insurance in this state. So remember, workers' comp is a state-by-state thing. So you might hear about a major employer in another state who that state considers their service providers to be employees or not. Well, every state is different. Let's now talk about what to do if there is an injury or an illness. The first thing the worker should do is get the necessary medical treatment as soon as possible. If you're an employer and you're on this call and you're hearing me, thanks for joining us. Please help your worker get medical care if the worker gets injured or ill. Please help with that. The next thing the worker ought to do is to tell the employer in writing within 30 days of the incident, but as soon as possible, tell the employer in writing that you've suffered an incident. That's a form of notice. And if you're going to do that, well, you should do it, but when you're doing it, please, a document or an email is the best way to do it because there's an audit trail there. Try to avoid sending a text message if you can because they're easy to miss, hard to find, and so forth. So a document or email is my advice. The next thing the worker does is file an employee claim. It's known as the C3. That's going to come to the board, and the employer and insurance carrier will find out about it. They will know about it. The easiest way to do that is filing it online. You can also get it on paper if you like, and you can send it on paper, but online is faster and easier and clearer too, by the way, because you don't have the variable handwriting. And then the worker should continue receiving medical treatment as necessary. So let's talk about benefits. There are two primary benefits here. There's the medical care and there are the lost wages. Let's talk about the medical care first. This is provided to an injured worker at no cost. It is a lifetime benefit in an established claim. When we say an established claim, that's a little piece of jargon that means the claim has been decided that this is a, for want of a better word, valid workers' comp claim and benefits are payable. So in an established claim, medical care is a lifetime benefit. We do get that question from time to time. Someone who had a claim 15 years ago will contact us and say, what do I do? I had a claim 15 years ago and I'm having a flare-up today. Well, it's an established claim. Go get treatment. By the way, if you're an insurance carrier and you're listening to me, please don't tell your subscribers that their claims are closed if they're not closed. A claim can only close on a Section 32. So if it's an old claim, I don't know how you have it marked internally, but please don't tell the injured workers that their claims are closed, because that implies there's no benefit when clearly, unless a settlement was struck, there is certainly medical care as a lifetime benefit. And another benefit that is sometimes overlooked, but it's there and it's on the books and people can and do take advantage of it, which is the transportation costs for travel to and from medical or healthcare appointments. Those are reimbursable to the worker. The worker would use Form C-257, and that you can get that on our website. You can contact my office, and I'll email you one or send you a link, no problem. But it's a very simple matter of just putting down, where you started, where you went to, and where you finished, and then the number of miles traveled, and there's a mileage rate. Currently, it's about 58 cents a mile. If you need to get that, you can certainly use mapping software from Google or Apple or MapQuest, whichever one you want. And you submit that to the insurance company, and you should send us a copy so we can see it, because we can help you, especially in my office, if the reimbursement's not forthcoming in a timely way. Also, if you took a mode of transportation, you took a train, you took a bus, well, see if you can get a receipt and submit the receipt on that one. Also, you can get this mileage if you have to travel to an independent medical exam, also known as an IME. That's when the insurance company asks you to see one of its doctors. You can get the mileage to that as well. Here's a tip. You're an injured worker, you go into the doctor. Please remind them of their responsibility to file their reports and their bills in a timely way. Because if they don't file their bill in a timely way and you send in a mileage request for that visit, well, the insurance company is going to look for a bill from that doctor to validate the fact that you saw that doctor. So if there's no bill on file, well, the reimbursement is going to be questioned. So try and encourage your providers, if you can, to file as promptly as they can. And if you're a provider and you're listening to me, and I know some of you are, let's try and get those bills and those reports filed as quickly as you can. It just helps the entire system, including you. Okay, the cash benefit. This is known as the indemnity benefit. This is the lost wage benefit. The way it's calculated is the following. If a worker is not working, okay, if the worker is 100% disabled, there's going to be a medical report, number one, that says, in my opinion, this worker is 100% disabled. Okay, now the insurance company is going to pay the benefits, and they're going to work with the average weekly wage of the worker over the past 52 weeks. Okay, so they go back a year, calculate, and we do this too at hearings sometimes, or the board does it, calculate the average weekly wage of the worker, what they earned on average, and then the benefit is 2/3 of that amount up to a cap, up to a maximum. The maximum benefit right now for injuries that have occurred after July 1 of this year is $966.78. It's right there on your screen. That maximum amount changes every July 1st, and it's based on the average pay of all workers in New York State. So this is an example of when it's very good to have investment banking and professional baseball and basketball and football and hockey in your state, very high wage industries. they push up that average because it's just an average. Every claim is temporary, except the fatality, but every claim is temporary until it comes to the point where a worker has a permanent injury. So you need time to assess it to get to permanency. So what I'm saying is you will see at the beginning of a claim the language that says temporary, temporary total, temporary partial, and this is replacing the lost wages. The claims can move into permanent status, permanent total disability, permanent partial disability. That usually comes down the road. A year, 18 months, 2 years after injury is a typical time frame because you have to give the body a chance to heal. So that's what I'm trying to say is that the benefits will come to the worker. It's called a weekly benefit. The checks actually go out every 2 weeks, but it's considered a weekly benefit for the period of time while the worker is not working. Or if the worker is 50% disabled, as determined by medical reports, well, the worker would get 50% of the benefit amount because the worker's 50% disabled. There is another benefit that I'd like to specifically mention that's called total industrial disability. Total industrial disability is a benefit that is not frequently used in this system, but it's a permanent benefit, and it is called for when a worker is very disabled, I'll call it, maybe not 100% disabled, but has a very high percentage of disability probably, and also some other factors that probably prohibit that worker from being gainfully employed again, such as age or I should say because it's a multiple number of factors: age, education, skill set, facility with language. So I'm trying to say there are factors beyond just the level of disability, these other employability factors, which could be considered in a claim that could result in the benefit for total industrial disability. This is something that workers can review and apply for, particularly if they have been receiving benefits for a number of years that might expire in the near future, such as a permanent partial disability. Finally, there are payments for the loss of use of a limb. This is called a schedule loss of use benefit. Schedule because it's paid according to a schedule, loss of use because the worker has permanently lost the use of a specific part of the body. When we say limbs, we're talking about arms and hands and fingers, legs and feet and toes. And then I just want to also mention there is a benefit for a facial scar and for loss of vision and loss of hearing. The schedule loss of use benefit that I want to mention specifically is one of those benefits that's going to be thought about when the worker heals as much as the worker's ever going to heal. That's a point that's called maximum medical improvement, which means just what it sounds like. This is the maximum amount of medical improvement that you are able to achieve. That's determined by the doctors. So if that should happen to a worker who, say, tore a rotator cuff in the shoulder and it's impacting the arm, well, an arm is a limb, and so if the worker comes to the point of maximum medical improvement, say a year and a half after injury, goes back to the treating doctor says, Adam, I believe that you have lost 25% of the use of your arm permanently. This worker has a permanent bodily injury now due to employment. The worker has to live with that for the rest of his life. There's a benefit for that. They would go on the schedule and look up arm, I think an arm is 288 weeks of benefits. So if the arm was permanently lost, either amputation or the use was permanently gone, the worker could conceivably receive 288 weeks worth of benefits in one check. But in our instance, 25% loss of use, they would go on the schedule and they would take 25% of 288 weeks, and the worker could qualify for the benefit of that amount. And of course, it's number of weeks times the benefit rate as determined by the average weekly wage, like we discussed earlier. We had a question before we began when you all were signing up. We did have a question about death benefits, so let's now talk about the other major benefit area for the surviving families of workers who perish on the job due to employment. Funeral expenses are payable, and you have the rates up on the screen for you. In New York City, Long Island, Westchester, Rockland, it's up to $12,500 based on what you actually spent. The other New York State counties, $10,500. Weekly benefit payments are payable to the surviving family. These are the surviving family members who could receive that benefit in the workers' comp system. Spouse, children up to 18 years of age, or children up to 23 years of age if they're attending college or higher education, to be technically correct. It's also payable to disabled or blind dependents. If none of those parties exist, $50,000 is payable to the parents of the worker. The parents are divorced, they could each get $25,000. Finally, if none of these people I have named exist, the estate can be paid $50,000. If there is a cousin or a great aunt or someone who is very close to the worker, well, that person has to deal with the estate. We don't do those types of relationships in the direct payment of benefits. And my office will work with the family to help them apply for the benefit. We also have a fact sheet available on this benefit. Let me just put in a plug right now. We have a number of fact sheets directed towards workers, specifically about the benefits and the processes of the workers' comp system, including one on the fatality benefit. So please visit our website, wcb.ny.gov. Go to the very bottom and click Publications, and you will get the list of all of our publications. I've worked on many of those myself, so I'm definitely urging you to check them out. Here's another publication. Can I receive workers' compensation benefits if I get COVID-19 while working? Yes. Yes, you may. Let's talk now for a few minutes specifically about COVID-19 and the claims that can result from it. This is a fact sheet that's available on our website. I would urge you to get it. COVID-19 is an infectious disease. Infectious diseases are payable in the New York State workers' comp system. Tuberculosis, asbestosis, well, asbestosis is not infectious, but infectious diseases contracted on the job are payable in New York State. Can't speak for every other state. I can speak for New York State. We call that compensable. Okay, so if you ever hear that term, I would like to bring your attention to the middle to bottom portion of this sheet. Here's the special information about COVID-19 I think you should know. What work environments are more likely to result in COVID-19 claims? Well, there are some professions that we know workers have a greater chance of exposure. Healthcare workers, first responders, transportation and correction officers, food service and retail workers, people who are dealing with the public. However, just want to make the point, this benefit applies to any worker. It's not limited to them. We just call them out because they are probably at a greater risk, and frankly, I think we all owe them a great debt of gratitude. But any worker who believes he or she contracted COVID on the job should be filing a claim. Now, the very last paragraph on this sheet here, I'm calling it out. The information a worker might need or should be aware of to demonstrate that the COVID-19 claim is work-related. You do not need to point to one moment in time where you think you might have picked it up. You do not need to point to one method of exposure, but workers can demonstrate their risk by talking about the nature of their work, the extent of their work with the public, or in an environment where exposure to COVID-19 was prevalent. Ladies and gentlemen, a workers' comp claim needs two elements. It needs a notice of an incident, and it needs a medical report. That is any workers' comp claim. If a worker has COVID and believes he or she got it at work, you're going to need to see a doctor and have a discussion with the doctor about where you work, what your duties are, how frequently you're there, contact with the public, all the details of your workplace, because the doctor is going to give an opinion regarding whether he or she believes that you were exposed to this at work. So you want to give the doctor all the information necessary to file an informed opinion. If you have received a contact from an insurance company or from the board asking for a medical report because you don't have one in your file, well, good time to go see the doctor and get that report, because it's a necessary element in a comp claim, the medical report and the notice. If you have a positive test result, file it. If you got your positive test result via telephone, as so many people did, particularly back in March and April, get a written copy of it and file that, please. You're demonstrating your exposure to COVID in filing your comp claim, so let's get as much information into that as we can. Okay, if you have questions on this, you can certainly contact us, and I would recommend that, that sheet to you. There are penalties that are payable from the insurance carrier or the claim administrator for late payment. Some of these penalties are payable to the board, and some of them are payable to the worker, himself or herself. Now, we mentioned the worker having to file a claim, or recommending the worker file the claim. Well, the insurance company, once it gets notice of the incident because you told it about the incident, well, they have 18 days to file notice as well. Or they have 10 days from when you told them, whichever is later. So the worker tells the employer should be contacting its insurance company immediately, telling them about the incident, so that the insurance company has the ability to conform to these laws on the books here. 18 days from incident, they should be reporting it to us. If the worker's out of work, they should also be beginning the payment of benefits within those 18 days. Otherwise, they could get a penalty, and that penalty system is up, running, operational for years now. There are also these other thresholds for penalties. 10 days after a decision is filed by a judge, or 25 days in the case of ongoing payments. If the check doesn't come, it could be considered late. And it's possible to appeal a decision. There is interest that is also due after an appeal in some circumstances. So This is a big picture now. The claims that have the best outcomes have these features. The workers are receiving prompt and appropriate medical care. The injury was reported promptly. The benefits are being paid promptly. And then finally, uh, the employer might have a return to work program. That is very important. And if you're an employer or a worker who's not 100% disabled, maybe 25% disabled, maybe you want to go back to work, you feel like you're in a position where you could go back to work if you had some slight modifications to your duty, that's called return to work. Employers, I would encourage you to welcome your workers back and try to work within their restrictions. So, workers, you're going to see your doctor. Your doctor says, well, I think you're 25% disabled. I think you might be able to return to work because you told me what you do. That's a good idea, workers. But I think you should work within these restrictions. Don't lift more than this many pounds. Don't stand for more than this many hours. Those are called restrictions for a period of time, and the employer very probably could accommodate you coming back to work within those restrictions. That's called transitional duty or light duty. Some other helpful tips from us: if you're a worker and you get an inquiry or a document from the board, please respond to it in a timely manner. If the board is trying to reach you, it's usually for good reason. If you move, please make everyone aware of your new address. Also, if you're going to be making any agreements or signing anything, please understand what it is that you are signing. Ask questions. It's possible you might have a hearing. Attorneys are definitely part of the workers' comp system. A worker can certainly retain an attorney. It's not mandatory, but it can be extremely helpful, especially in a disputed claim or in a very complex claim, because the insurance company is definitely almost certainly going to be sending an attorney to a hearing. So if you have a hearing, you're going to get a notice, and the hearing will probably be roughly 3 weeks, 4 weeks from when you get the hearing notice. The instructions for attending the hearing will be on the notice. We'll talk more about that in a moment. There might be witnesses called, depositions of providers, healthcare providers might be taken. It's not like television. We don't use the formal rules of evidence and procedure that civil courts and criminal courts use. We're not a court. That's why. This is called administrative law. And also, in the event that the employer was not carrying insurance when it should have been, well, there's probably going to be a hearing, and you'll be dealing with something called the Uninsured Employers Fund. That's something that the board operates, and that usually sweeps up several hundred claims a year out of the 170,000 claims a year we receive. So even if the employer is not carrying insurance, the worker should proceed with filing a claim and pursuing the claim, because the board will advance the payments and then will bill the employer personally. Okay, so you're having a hearing. Well, we're in a pandemic, so we are not having in-person hearings right now, but we're making great use of our virtual hearing system. This is essentially a teleconference where the parties to the hearing, judge, worker, employer, insurance attorney, worker's attorney if there is one, witnesses, they can all join a teleconference. And you can do that on a phone or on a tablet or on a computer. You just need a microphone and a camera attached to an electronic device. When you get your hearing notice, the directions for how to do this will be on it. If you don't wish to do this, well, there will be instructions for how to telephone into the hearing. Please follow them. I can tell you from experience, this works. It's pretty sharp. If you're going to do telephone, please follow the instructions for that as well. If you're a worker, I'm urging you to participate or attend your hearings. Finally, we're rather proud of the virtual hearings because, number one, well, we have the app available through Google and Android, and Apple. Google and Android are the same, aren't they? We have it available in the app stores. But number two, this has enabled us to continue hearings uninterrupted during the pandemic. Finally, here's a little more information. That's our website. If you're a worker, consider signing up for eCase because then you can see all the documents in your file. If you have a legal representative, make friends with your legal representative. Ask that person questions and to explain things to you. That's why they're there. Sometimes workers go to their employer with questions about workers' comp. The employer might not have the most current information. You can come to us. Our contact information is there on the screen. And then finally, a quickie here, I want to tell you, everyone, that we are creating an entirely new claim system called Onboard. It's going to replace multiple systems we have and paper-based claim systems with one web-based platform. So it's very deeply in the 21st century here. Onboard is going to have real-time claim data. It's going to have a lot of new self-service features where any party can find out more information more easily, easy access, and one of the big benefits is going to reduce the amount of overall paper that's in the workers' comp system, which increases responsiveness and moves everything along faster. We're going to release it in multiple waves. So as soon as we finish something important, we're going to release it, such as in spring 2021. So in the spring, which is not that far away, we're going to have a number of features that healthcare providers can use that is going to greatly improve their experience in workers' comp. You can stay informed if you want by visiting our website at the Onboard page. Here are a whole host of other ways to stay in touch with us. We're on social media. The YouTube, we have dozens upon dozens of helpful and informational videos on that YouTube channel. Finally, the very last one. If you come to our website, you go to the bottom, you'll see that icon keeping you informed. I would really recommend that you click it and select what information you want to receive about workers' comp. We definitely do not inundate you, but if something important is happening, you will know about it from us, and we're the best source of that information. So we're going to leave up the contact information, and I'm going to turn it back over to Adam because we might have some questions.